Industrialization, in Malaysia, has undergone a significant evolutionary process over the past decade. Similarly, the legislation related to OSH also has undergone significant changes. However, the 28-year-old OSH-related Act needs to be amended, in line with new challenges in occupation. After long years of debate, the OSHA Amendment Act and the FMA Repeal Act were gazetted on March 16, 2022. Why do these laws need to be migrated? Number 1. The laws can facilitate to industries. Now, the industries have to comply with one act only compared to 2 acts before. Number 2. To ease the administration of OSH legislation. Now, the OSHA and FMA have combined into one act. And, number 3. The new amended act has intent to strengthen existing legislation in OSH. By these amendment of 2 OSH-related laws. What is the significant change? Firstly, re-administration of OSH legislation. The Factories and Machinery Act 1967 is repealed. However, the operation of repealed act be dealt for the case of a pending application, the continuance of legal proceedings, etc. under the repealed act. Legalize the administrative work, through the empowerment of enablers in OSH legal provisions. It provides more value added, for enhancement of self-regulation concept in OSH. Hence, this concept of a self-regulating approach, will not be too dependent on government enforcement. Number 2. Higher protection of employee. The new OSH Act has now applied to all places of work. Workers has the rights about OSH including, the right to remove themselves from imminent danger. Also, the term of injury in occupational health, has now to be addressed as adverse effect. Number 3. OSH Management System. OSH Management System, through the formulation of OSH policy, has been further enlightening to all places of work. There is also, the new requirement of risk assessment, which must be conducted at the workplace. The new requirement of law also, has enforced the development, and implementation of procedures, for dealing with emergencies at workplace. Number 4. Broader responsibilities of employer, and principal in OSH. Mandatory requirement for principal employers, to ensure the safety of contractors, and subcontractors, including those employed by them, as far as reasonably practicable. Company directors or highest officers, may be charged severally, or jointly for offenses under OSH Act. The burden of proof, is upon the company directors, or highest officers to prove they are not liable. Next is, increment of penalty, from Ringgit Malaysia 50,000, to 500,000 Ringgit for offenses, including the failure of employers to formulate, safety and health policies. Second penalty, of increment to Ringgit Malaysia 200,000, which was previously only 20,000 Ringgit, for violations under Section 20 and Section 21, in the subject of manufacturer's duty on plant and materials at the workplace. Number 6, empowerment, and accountability of competent persons, licensed persons and OSH training providers to be legally enabled, in the OSH administrative task. Next, safety, and health officer, does not necessarily, to have a status of employee in the company. However, each appointment of SHO is only for one place of work, effective at any one time. The new insertion of requirement, for the appointment of occupational, safety, and health coordinator, at the place of work. It could be believed that, the OSH implementation, can be further enhanced, by the appointment of competent person. Other changes are, medical surveillance should now be known as occupational health service. And, the meaning of employer, is more clearly referred to through a single definition, by removing the terms, such as immediate employer, and principal employer. Therefore, the summary of amendment of OSHA Act, shall be consist of, 2, new parts in, amended law, 34 amendments, 10 of, new sections, 4, substitutions, 2, deletions, and, finally, 1 new schedule, will take effect, for this new amendment, of OSHA Act.